Thank you. Good afternoon, everybody. Thank you all for joining us today. It's great to have you with us, and I hope this is going to be an informative and interesting session for all of you involved. My name is Claire Russell. I'm one of the directors at NQC. We're the providers of the supplier assurance platform, but I'm going to tell you a little bit more about that later on. I'm honoured this afternoon to be joined by Sarah and Anka, who are both very experienced lawyers working at Field Fisher. For those of you who don't know Field Fisher, they're a European law firm which is active in many dynamic sectors. They have more than 1,000 lawyers worldwide and work within most of the major European business centres, as well as within Asia, in China, and also within Silicon Valley within the US. My fellow speakers, Sarah and Anka, have been practicing commercial and distribution law for many years, and they've been particularly involved in the implementation of the due diligence requirements within the Supply Chain Act. So I feel they are very well placed to provide the briefing today, and I'm looking forward to hearing more about what they have to say. The focus, as I'm sure you're aware, of our session today is all about the upcoming German Supply Chain Due Diligence Act, which is quickly becoming upon us and will come into effect on the 1st of January next year, 2023. Next slide, please. So just to remind you, refresh your memory on the agenda that we are hoping to cover today. So our agenda involves Field Fisher initially providing us with a really comprehensive overview of the scope of the Act, and also then focusing in on how you should consider implementing the requirements of the Act into your contractual agreements that you have with your suppliers, etc. And then I will come back on and follow up with some further details, focusing really on some of the central obligations of the Act and try to give some practical insights as to how we're supporting clients to get ready for the Act as it comes into effect next year. So without further ado, I'd like to hand over to Sarah and Anka at Field Fisher, to start us off. Over to you, ladies. Thank you.
Thank you, Claire, and hello, everyone. Thank you again for joining my colleague Anke Sassmannshausen and myself for this afternoon's session with the topic, Are you ready for the German Supply Chain Act, officially called Act on Corporate Due Diligence Obligations for the Prevention of Human Rights Violations in Supply Chains, or in German, the Lieferketten-Sorgfaltspflichtengesetz. To avoid further tongue twisting, I will briefly now only refer to it as the Act or Supply Chain Act. And it won't be long, now only 2.5 months left until it enters into force after long legislative procedures and discussions. The aim of the Act is to make globalized supply chains socially and environmentally sustainable and anchor human rights and certain environmental considerations in companies' operations and governance. The starting point were the UN Guiding Principles on Business and Human Rights, or the German government's National Action Plan, which is based on these principles and which relied on a voluntary self-commitment. However, the hope for effect of this voluntary commitment failed to materialize, which is now why we now ended up with the Supply Chain Act. In February this year, the EU Commission adopted a proposal for a directive on corporate sustainability due diligence. So a EU-wide regulation is also on its way, and this means that the current German Act is only a transitional stage and will undergo fundamental changes in the near future, and its scope of application will also be expanded. But for now, let's first look at today's topics. As our time together is limited, I can only give you a high-level overview of the contents and structure of the German Supply Chain Act and a quick glance on the EU proposal for the directive. I will then talk about the companies directly falling within the scope of the Act, the norm addressees, and the calculation of the employee thresholds, and then hand over to my colleague Anke, who will take a closer look at the legal texts, the drafting of contracts, liability issues, and sanctions. Supplier assurance will then talk about ensuring compliance via their platform-based service offering, leaving some time after the end of the webinar for questions and answers. Let's start with the basics regarding the Supply Chain Act. The Act enters into force on 1st of January. and obliges entities falling within its scope to adequately comply with human rights and environmental due diligence obligations in their supply chains. Who, or better, which entities directly fall within the scope of application? Well, initially from January 1st, these are companies regardless of their legal form. So this also includes or may include public law institutions, with at least 3,000 employees in Germany. And as of 2024, the threshold drops to 1,000 employees. I will talk about the types of employment that are considered under the Act in a bit, and also briefly discuss the method of calculation. But let me now tell you one thing. If your company has fewer employees, you should nevertheless stay tuned and listen to this interesting topic, because it is very likely that the Supply Chain Act will still be relevant for you, as well as it has indirect effects on your company, if it is a contractual partner of a large enterprise. And also due to the EU directive, which will have a wider scope of application, which will come in a few years. Now let's get to the term supply chain, which is defined in Section 2 of the Act. Let me read this definition to you. The supply chain, according to the Act, is defined as follows. The supply chain within the meaning of the Act refers to all products and services of an enterprise and includes all steps in Germany and abroad that are necessary to produce the products and provide the services, starting from the extraction of raw materials up to the delivery to end customer. And it includes the actions of an enterprise in its own business area, the actions of direct suppliers, and the actions of indirect suppliers. I will get back on these three tiers in a moment when talking about the due diligence obligations a company has to fulfill with regard to its supply chains. I will now touch a bit on the protected legal positions, which are formulated as prohibitions in Section 2 of the Act. The Act refers to various international conventions enshrining human rights. As regards the protection of employees, for example, the International Labour Organization's core labor standards. The protection of human rights is clearly the main focus of the Act, and there are three major areas in this respect. The protection of employees, covering the prohibition of forced labor, slavery, child labor, and unequal treatment of employees, as well as the freedom of association, to name a few. Another area is the protection of natural resources, and there's also a category regarding protection from security forces, which is about the prevention of violence by such security forces. Environmental concerns are also protected, but to a limited extent, particularly where environment-related risks lead to human rights violations and where certain chemicals and substances become hazardous to people and the environment. These environment-related obligations stem from three international conventions. The Minamata Convention, which is dealing with the prohibition of mercury-added products and the use of mercury. The Stockholm or POPs Convention, dealing with the production and use of persistent organic pollutants, as well as the Basel Convention regarding bans on the export and import of hazardous waste. Climate protection is not covered, but this will change in the future after the proposed EU directive is transposed into German law, because this covers it. The various human rights and environmental risks shown in this overview are prevented and minimized through compliance with the due diligence obligations. So let's therefore dive into the core piece of the Supply Chain Act, the due diligence obligations. And as I said, the time is limited, so I try to just give a brief overview. The due diligence obligations are set forth in sections 3 to 8. Firstly and foremost, they only affect companies falling directly within the scope of the Act. But, which Anke will talk about later, they also have an indirect effect on companies which do not directly fall within the scope of the Act. There are actually 9 due diligence obligations as shown on the slide. And the first obligations are the requirements to set up a risk management system and to conduct a risk analysis, both prescribed by Section 5 and 6 of the Act. There's a legal leeway as to how exactly this is to be implemented. So the Act is in many ways not 100% clear on this. And the establishment of adequate and effective risk management requires, among other things, also the designation of a person who's responsible for monitoring the risk management. And the Act suggests to appoint a human rights officer. The management must regularly, at least once a year, inform itself about the work of this designated person. And this person should also report to the management. It should also be mentioned that already existing risk management systems may be utilized, but they must, of course, be adapted to the specific requirements of the Act. As part of the risk analysis, enterprises have to identify, weigh, and prioritize the risks in their supply chains. The risk analysis must be reviewed on an annual basis as well as on an ad hoc basis. This means, for example, if the risk shifts due to a different sourcing origin, or when new products are released and these things. So not only on an annual basis, but also ad hoc. This is a returning scheme of the Act to put certain mechanisms in place and then frequently review them in order to improve on them. If in the course of conducting a risk analysis, human rights and environmental risks are identified in the company's business area or at the level of direct suppliers, appropriate measures must be taken immediately. At this point, I would also like to mention that the Federal Office of Economics and Export Control, the BAFA, this is the competent German regulatory authority, has very recently published a very helpful handout containing some guidance on how to conduct this risk analysis and risk mapping. I'm not 100% sure if this is also available in the English language, but this can, of course, be checked on the website. Next, we have the necessity of a policy statement, the elements of which are listed in Section 6 of paragraph 2 of the Act. Companies must adopt a policy statement on their human rights strategy in which it is described procedures for complying with their human rights and environmental due diligence obligations, and which specify particular risks which have been identified as a result of the risk analysis. And lastly, such policy statements shall also define the company's expectations towards its own employees and suppliers. Once a risk or potential risks are identified, companies must anchor risk-based preventive measures, as described in Section 6 of the Act. And that means that the measures must be adapted to the type and level of risk. In their own business area, these should in particular include the development and implementation of suitable procurement strategies and purchasing practices, including also contractual assurance, which Anke will come to talk about in a moment. The implementation also of training and risk-based control measures. With regard to direct suppliers, human rights and environmental expectations should also be taken into consideration in the selection process. And this is also the topic of the next presentation by a supplier assurance who offer a platform for a platform for supplier self-assessment for these purposes. Remedial action must be taken in the event of violations have occurred, and this is covered by Section 7 of the Act. If a company determines that a violation of a protected legal position has occurred or is imminent in its own business area or with a direct supplier, or if there is substantiated knowledge in this respect with regard to an indirect Tier 2 supplier, appropriate remedial action must be taken immediately. However, a termination of the business relationship with a supplier is only required in very exceptional cases of severe violations. Then there's also the requirement for a complaints procedure, which is covered by Section 8. A whistleblowing system must be implemented that enables internal as well as external stakeholders to notify human rights and environmental risks and violations that have arisen as a result of a company's business operations. The rules of procedure must be publicly available normally on the website. These due diligence obligations described are flanked by reporting and documentation obligations. Covered enterprises must annually, no later than 4 months after the end of their fiscal year, make publicly available this is normally done on the website, a report on the actual and potential adverse impacts of their business activities. And this must be submitted electronically also to the Federal Office of Economics and Export, the BAFA, the competent authority. These reporting obligations are also accompanied by documentation obligations, and there's a statutory retention period for documents of 7 years that applies. These explained due diligence obligations must be implemented in an appropriate manner for the companies falling directly within the scope. It's important to note that there's no obligation to succeed, but only an obligation to make an effort and comply with the duties in an appropriate manner, meaning that companies are not obliged to prevent human rights and environmental violations by all means, but rather that this is determined on a case-by-case basis, the measures that are taken, and these measures must be appropriate and reasonable for the respective company, and also, as I said, depending on the type of violation and the influence the company has to avoid this. Now, let me briefly give you an outlook on the legal situation in Europe. The draft Sustainability Due Diligence Directive has been published and was presented by the European Commission this year in February, and is still going through the legislative process. It will probably take another a couple of years until 2025 or 2026 for the legislative process to be completed and the deadline for transposition into national law to expire. But what can be said already is that the directive will lead to an expansion of the due diligence obligations and the scope of application of the German Act. As you can see on the slide, the thresholds are lower, but combined with a certain minimum turnover. And in any case, more companies will fall as a consequence directly in the scope of application. And unlike the current German Act, the proposed directive sets out certain obligations that support the achievement of the EU climate targets and therefore also aims at combating the climate change. Liability and sanctions will also be further reaching than under the German Act in its current version, and particularly the civil law liability, which is not touched by the German Act, is widened. The proposed directive explicitly provides for a civil law liability for due diligence violations to prevent potential or bring to an end adverse impacts. And liability is not just limited to the company's own violations, but also extends to violations by subsidiaries or suppliers. Now that's it for the brief overview of the Act and the proposed directive. But before I pass on to my colleague Anke, I would like to quickly go a bit more into detail about the target companies falling directly under the German Supply Chain Act and the calculation method for the employee thresholds, as we have frequently received questions about this from our clients. So this seems to be a question which is of interest to many of you. Companies that directly fall within the scope of application, irrespective of the legal form, must be domiciled in Germany and either have their central administration in Germany or their principal place of business, administrative headquarters, or corporate seat. And in addition, the Act also applies to foreign entities having a branch office in Germany. Now, as to the required headcount, such companies must initially have 3,000 employees in Germany, and this scope will expand to include companies with only 1,000 employees a year later, as of 1st of January 2024. Which categories now count towards these employment numbers? Not only regular full-time employees, but also part-time employees and temporary agency workers with an assignment duration of more than 6 months. And also even employees of German companies who are temporarily posted abroad not only for a very short period, are considered decisive to calculate the headcount. In case of affiliated companies, there is a certain attribution mechanism, which I will now explain next. Next slide, please. Thanks. Pursuant to Section 1.3, all employees of affiliated enterprises employed in Germany are taken into consideration when calculating the number of employees of the parent company. Affiliate company is a non-technical term which includes all types of affiliated companies within the meaning of the German Stock Corporation Act, that's Section 15 of the Act. And so this includes subsidiary and parent companies, controlled or controlling enterprises, members of a group, for example. This means, as an example, that a parent company must consider the headcount of its subsidiaries and second-tier subsidiaries. And it is important to note that the employees are always counted from the bottom up to the top and not considered on each level, but only at the top group parent located in Germany. The scope of consolidation only includes domestic parts of the group of consolidated companies. Another question is whether the due diligence obligation can be fulfilled centrally by the parent company. In this respect, it depends on whether the subsidiaries themselves reach the employee thresholds, and if so, they would have to fulfill the duties themselves, but it then depends on whether the parent company has exercises or can exercise a decisive influence on these companies. If this is the case, the risk management at the level of the subsidiary can also be carried out by the parent company instead of the company itself. So I will now pass on to my colleague Anke, and I'm also, of course, happy to, after the entire webinar, answer questions. Anke, please continue.
Yes, thank you very much, Sarah. So now that we have had an overview of the scope of application of the Supply Chain Act, the individual due diligence obligations, and in particular the advocacies of the Act, I would now like to take a view at how to take into account the due diligence obligations when structuring the contractual relationships within the supply chain. Let's take another look at the three different levels of the supply chain that are relevant under the Act, namely the level of the own business area, the level of direct suppliers, and the level of indirect suppliers. A direct obligations for contractual agreements with regard to due diligence under the Act exists for the relationship between companies, who are actually adversaries of the Act, and its direct suppliers. For this relationship, the Act stipulates that the adversary must obtain a contractual assurance from its direct suppliers that they will comply with its human rights and environmental expectations and address them appropriately along the supply chain. As a result, there is a need for the direct supplier to pass on certain obligations to its own suppliers. This is to address its contractual obligations and ensure compliance by the company's indirect suppliers as well. As you can see, the due diligence obligations from the Act are therefore not only relevant for companies directly affected by the Act, but also filter through to the further levels of the supply chain by way of contractual agreements. Even if your company is not yourself a norm adversary, as Sarah has already pointed out, it is nevertheless advisable to proactively familiarize yourself with the obligations arising from the Act. This will be helpful to ensure a smooth process and not to run risk of business relationships coming to a standstill because certain requirements cannot be met at short notice. In addition, you will then be in a better position to assess whether the requests from your customers are appropriate or go beyond what is actually required by the law. I'd like to add one remark on the own business area of companies that are directly addressed by the Act. In the case of affiliated companies, it may also be appropriate to address certain due diligence obligations within the scope of intercompany agreements. This is because a parent company may also have to ensure compliance with the Act vis-à-vis its subsidiaries if the action of its subsidiaries are attributed to the parent company. On the next slide, we would now like to take a look at which documents are relevant for structuring your own contractual relationships in accordance with the requirements of the Act. First of all, if your company is a norm advocacy, there is an obligation to draw up the policy statement that sets out the company's human rights strategy and the resulting expectations for the supply chain. This includes, for example, setting out a strategy for the selection and ongoing management of suppliers. And this policy statement must also be communicated to the direct suppliers. While the policy statement stipulates the basic pillars for the human rights strategy, companies can set out specific expectations for their suppliers in a supplier code of conduct. By this means, the human rights expectations towards a supplier can be specifically identified and included in the contractual relationship with the supplier. This can be done, for example, by means of an annex to the supply contract or by way of reference in general terms and conditions. However, when including the supplier code of conduct by way of general terms and conditions, please take special care that the general terms and conditions are effectively included as part of the agreement. In individual cases, it may also be necessary to agree on special terms with individual suppliers, for example, because there is an increased risk in relation to such supplier. In this case, companies should consider to define their suppliers' obligations in more detail in framework supply agreements, for example. In addition, please make sure that the contracts with the suppliers provide for appropriate remedial measures for breaches of the agreed contractual obligations. When drafting contracts, you should also take into account the fact that certain clauses may conflict with the prevention of human rights violations. For example, very short delivery times, low purchase prices, or long payment terms can intensify problematic conditions with regard to the human rights situation at the supplier level. So what exactly should the clauses in the contracts with the direct suppliers should look like? Let's take a look at the next slide. First and foremost, suppliers should be required to comply with the requirements of the supplier code of conduct. However, it is also important to create a certain flexibility by establishing a right to change the obligations from the supplier code of conduct as need be at a later point in time. This may become relevant, for example, if the supplier code of conduct needs to be adapted due to a changed risk analysis. It is possible to request the supplier to purchase certain products only from selected and previously audited upstream suppliers, or to ask for certain product certifications. In addition, obligations to conduct training or further educations with regard to human rights due diligence can be stipulated in the contract. You should also implement control mechanisms for the enforcement of the human rights related obligations. This can be done, for example, by on-site inspections or audits carried out by third parties. Finally, it's important that the contract provides for appropriate remedial measures that take effect when a direct supplier violates its due diligence obligation or if a violation is imminent. A plan to end or minimize the breach must then be established. That is, the supplier must cooperate in developing a joint remediation plan. If necessary, this may also involve to join forces with other companies within the supply chain or within the industry and industry initiatives in order to increase the possibilities of exerting influence on the supplier. It may even be appropriate to temporarily suspend the business relationship with the supplier. However, as Sarah has already mentioned, termination of the business relationship is only necessary as a last resort if the violation is very serious. The remedial concept is unsuccessful and no milder means are available. It is also important to have a so-called pass-on clause. This is a clause which ensures that the supplier must pass on its human rights due diligence obligations within the supply chain. in order to enable measures to be taken against the indirect suppliers as well. Let's now take a look at the next slide. With this slide, we would once again like to highlight the importance to keep in mind that the Supply Chain Act is guided really by the principle of appropriateness. This means that nothing can be expected from the advocacies of the Act that is not possible in view of its individual situation. Relevant criteria are the size of the company, the type of business activity, and the proximity to the supplier and the actual opportunities for exerting influence. Different challenges can therefore be prioritized. However, it is all the more important that basic contractual agreements anchor the implementation of due diligence within the supply chain. Before we pass on to Claire of Supplier Assurance, now a brief note on the possible consequences of the violation of the Act. The Supply Chain Act is of a public law nature, so that first and foremost public law sanctions are threatened, namely the exclusion from the award of public contracts for up to 3 years, or the imposition of a penalty payment of up to 50,000 euros in case of violation of administrative orders. Finally, fines of up to 800,000 euros or 2% of the average annual turnover can be imposed. As far as civil liability is concerned, the Act states that it shall not establish additional remedies based on civil liability. However, this does not include liability based on general principles of civil law. Well, details of the liability for violations of the Act are still subject of much debate. In any case, please bear in mind that the advocacies of the Act may have contractual claims of recourse against their direct suppliers. In addition, internal recourse within a company or group of companies may also be possible. Finally, I'd like to point out, as Sarah has previously mentioned, that the proposal for the EU directive expressly provides for civil liability for breaches of the relevant due diligence obligations. At the European level, we can therefore expect that affected parties will be able to assert direct claims for human rights violations or environmental damages in the supply chain against the advocacies of the directive. For example, such claims may be directed at injunctive relief or compensation for damages. And now I'm happy to pass on to Claire Russell of Supplier Assurance. Thank you.
Brilliant. Thank you so much. Thank you for such a comprehensive and insightful overview. I think there is a lot to understand within the Act, and that was really helpful to give a great overview. What I'd like to do in this kind of final section of the webinar is focus in on some of the specific kind of due diligence obligations of the Act and talk a little bit more about the practical aspects for implementation, touching on some of the things that we've already spoken about and just bringing those to life a little bit. But first, just by way of introduction of kind of NQC and who we are, we are a UK-based kind of supply chain risk management company. We've been supporting engagement between buyers and their supply chain for over 15 years and have developed an online solution to deliver that supply chain risk management approach. The Act has been a very interesting, I guess, implementation for us because our focus continues to be helping organisations to understand their supply chain and the associated risks and also opportunities and strengths, primarily in the areas of corporate social responsibility, so looking at kind of environmental and human rights aspects. We're used to working at scale across thousands of suppliers all over the globe and work on a multilingual basis. Obviously, today's session is in English, and I appreciate my colleagues speaking in English today rather than German, but we have many other people in our organisation that have much more comprehensive language skills than I do to support the organisations that use our platform. We're based in Manchester, in the UK, probably most famous for football, as people will know us, not the weather. And here's a little picture of Manchester by night trying to look very exotic. So what we have actually created is a supplier assurance platform, a web-based platform to help the engagement of buyers and suppliers to assess risk. And I'll talk a little bit more about this later on in the presentation, but through the delivery of online assessments and through additional kind of services where we verify suppliers' information, we're helping organisations to understand suppliers' capability in these areas of corporate social responsibility, and actually providing feedback to suppliers by way of corrective actions, etc., to try and encourage suppliers to address risks and potential violations and issues that we see within their capability. But I won't labour on this too much because I'm conscious of time. So if we move on to the next slide, you're probably sat there thinking, well, what does a platform like Supplier Assurance really have to do with the Supply Chain Due Diligence Act? And as I've already mentioned, we were really interested when we started to hear about the Act and more detail about what's expected of organisations kind of came to light, because actually we're already supporting clients in delivering some of those expected outcomes and requirements of the Act. Our focus has been about encouraging organizations to understand their supply chain, who's in it, where they're located, to clearly define expectations, what's expected of an organization and its suppliers in relation to kind of corporate social responsibility areas, and actually giving a very structured way for organizations to assess and monitor a supplier's compliance to those expectations. And so you'll have heard from Sarah and Anka about the 9 areas, and you can see them here on the slide. But really, I wanted to focus in on what we call kind of the heart of the Act, and these preventative measures, and also talk a little bit about kind of remedial action and a bit about indirect kind of supplier risk, and delve into those a little bit more. So if we look at the heart of the Act, I really want to discuss kind of the policy aspect, the prevention, and also the remediation, those areas. And as we've already heard, in undertaking the risk assessment process and identifying those suppliers that need to be reviewed and assessed, for suppliers, both potentially new and existing, the Act has some very clear expectations about what you should be doing in this area. The first thing, as we've already heard, is that you need to have defined your expectations. That's through a policy statement, and this has to be shared with suppliers. So whether that's your own policy or whether you take some specific aspects of that and turn it into a code of conduct that's developed from that policy, this needs to be clearly shared with your suppliers. So there is absolute clarity on what you expect as an organisation from your suppliers as a minimum. And so you're able to then start to understand a supplier's capabilities and how they then match to the expectations that you have. Next slide, please. So let's delve into those preventative measures in a little bit more detail if we can. And again, some of this has been mentioned already, but I wanted to actually put this up on screen and just talk a little bit more. So this is a direct lift from the English version translation of the Act. And this talks about what's expected and what preventative measures as an organisation you must be putting in place in relation to your direct suppliers. So as we've already spoken about, in the procurement processes that you have in place, you have to be considering those expectations that have been defined when you select a supplier. So you need to be able to have a process in place to understand what the supplier's capabilities are in comparison to the expectations that you have, and can they and do they meet those expectations that you have set out. They might say they do, but what evidence might you need to get from suppliers so that you can verify that that is the case? So you need to be thinking about how you consider this within your procurement processes. You might already be doing this by sharing a code of conduct and testing how a supplier has implemented your expectations, but this is something that you need to ensure is embedded in your processes if you're not doing it already. And then, as we've heard, moving on to the second point, you have to get that contractual assurance from the supplier that they are going to comply with your expectations. And so getting their agreement on the code of conduct through the contractual arrangement is important. And also the key point is that not only will the supplier themselves, but as we've heard, that they will pass this on along the supply chain, and that's important. There's a training expectation. So the Act also says that you need to consider how you're going to train suppliers on your expectations and provide education, perhaps on areas where there may be a mismatch in capability. And you have to be checking on the effectiveness of this on an annual basis. And then the kind of final area, which has a lot more, I guess, link to the work that we are doing, is around control mechanisms and contractual control mechanisms, and the fact that you have to have a way of being able to verify a supplier's compliance to your strategy with those direct suppliers. And this control mechanism could be via audit, could be via assessment. There are different ways that you can actually implement this mechanism, but this has to be an ongoing process. So it can't be a one-off process where you assess the supplier and then you forget about them. You need to demonstrate that you are doing this on an ongoing basis and that you have a process and mechanism in place to do this. So what happens then if you go through this process and you identify that there is some risk or violation within your direct supplier? So the Act is very clear about what you need to be doing to address and what action you need to be taken. So the first thing is that you need to tell them what they need to do to take action and how you expect them to address it. That's really important. So you need to be explicit about and agree a plan with them about how they're going to minimize that violation or how it's going to come to an end. So you need to have the ability to be able to communicate that with the supplier and clearly articulate what's expected of them. You then have to try and work with them. So as both Sarah and Anka have highlighted, this isn't about finding a violation and cutting off a relationship with that supplier. You have to try and look at how you can work with the supplier to address that. Possibly, depending on the seriousness of the violation, there may be a need to consider some kind of suspension of the business relationship while the issues are addressed. But the idea is that you work together with that organisation to try and address those issues. And the last resort, the really last resort, is ending of the business relationship. Some of the interesting points that are referenced in the Act for you to maybe consider is also the Act specifically talks about joining forces with other organisations, perhaps within your sector, to jump on board of sector initiatives or standards to try and help with the influence of that supplier. So as an example, you will have probably seen on the earlier slide, we work heavily in the automotive industry, working with global brands like Volkswagen, BMW, and others around the world. And collectively, they have developed, in this case, a standard for corporate social responsibility. And together as an industry, they are pushing organisations to kind of understand their capabilities and adhere to a standard. So if there is an initiative within your sector, it's worth looking at how you can join that to collectively work together to encourage suppliers to improve. And the final point here is around having a concrete timetable. So you have to not only explain to the supplier what you want them to do, but you need to give them a clear deadline for when that action must be communicated, so that there is clarity between both yourself and the supplier about what they need to do and when they should have done it by. So let's talk a little bit about implementation and how you might implement these preventative measures. So clearly, depending on the volumes of suppliers that you may need to assess, you definitely need a structured approach to assessing that supplier capability. It has to be consistent. It needs to be auditable, because as part of the reporting process, you may need to be able to demonstrate what you are doing and how you are doing that in a consistent way. You have to think about integrating this into your existing procurement or commercial processes. You know, what process do you have that this might need to feed into? You know, when should that kick in, and how are you going to actually do it? This needs to be integrated both in terms of the tender management, but also the ongoing supplier management in terms of that control mechanism as we've spoken about. You definitely need to think about how you might identify and communicate those gaps or those areas of risk in supplier capability, and how you're going to actually communicate the corrective action plans that you expect to see from suppliers and the timescales, and how you're going to share that with suppliers, and then how you're going to manage that, because you're going to have a mechanism to be able to log and track the actions that have been agreed and when the timescales are that they need to have addressed that by. Obviously, you need to factor this into your ongoing risk management processes. And so thinking about the business impact of these gaps or violations or issues that you might find, they have to feed into the process to be able to consider the potential impact, and obviously feeding the learning into your existing risk management processes. And then the other thing, as we've kind of already noted, is from a compliance monitoring point of view, it can't just be a one-off exercise. So you can't just do this once with a supplier and then kind of tick the box and think, I've done it. This has to be an ongoing cycle where you can demonstrate that you are monitoring the compliance and the actions of suppliers in relation to your expectations. And then finally, remember that this doesn't stop at direct kind of tier 1 suppliers, that there are indirect suppliers. So where a violation has been flagged through the complaints mechanism that you've set up, you have to then look at addressing that if the violation is highlighted. And so everything that we've just spoken about, you need to think about how you then would implement that down the supply chain to those indirect suppliers. So we've got a few more minutes left before the end of the session, and we'll take some questions and answers. But one of the other things that I wanted to do, I guess, to bring this to life a little, as I'd mentioned earlier, is to talk about the approach that we have developed over the last 12, 13 years now, working with a range of industries, most notably automotive, as I mentioned earlier, to develop a approach that actually mimics part of what is required in the Act in some of the areas that I've spoken about. This is a cycle that we've developed through the platform that we have provided, the supplier assurance platform. And this is an approach of interrogating suppliers, so understanding their capabilities. Kind of suppliers through the system submit their data about their capabilities so that a buyer can understand and compare their capabilities to the expectations that they have to make sure that there is a match. As part of assessing a supplier's capability and interrogating their capability, we ask suppliers to provide evidence of what they're declaring. So if they tell us that they meet an expectation and they have X or Y policy or standard or process, we ask them to share evidence, and then we verify this. So we review those documents so that the buyers that are using our platform have the added assurance that we've checked that the supplier is doing what they say they're doing. If there are any deficiencies or gaps in the capability that we've identified, then we go through a process of recommending corrective actions to the supplier to tell them what they need to do to address the concerns. And then the final stage of the process is actually where the buyer can set a deadline for when the corrective action needs to be addressed, so that there's no ambiguity around kind of the importance of the action and when it needs to be taken. So as you can see, hopefully from kind of describing that approach, you can see why we were probably excited is the wrong word to use, but we were really interested to see the detail of the Act as it emerged, because it's actually describing fundamentally what we've developed and been implementing for kind of over the last 10 years. The platform that we have created automates this process of enabling engagement at scale to support that kind of ongoing management of supplier compliance and understanding the supplier's capability. So I do have a few more slides just to walk through this in a little bit more detail, and I'll do that relatively quickly so that we've got time for some questions at the end. I can see that we've had a couple of questions come in, so we will pick those up in a few minutes if that's okay. So just to reconfirm some of the aspects that I've spoken about in the last slide, what we're doing in the platform is giving organizations the ability to manage this approach of kind of assurance through this due diligence cycle with some of the features that we have in the platform. So we, at an industry level, for example, in automotive, are using the combined power of that industry to work with hundreds and thousands of suppliers to get them to come and submit information through our platform about their capabilities. We're comparing those capabilities to our buyer expectations. We're verifying that that information the supplier has provided matches their declaration. We're providing feedback to both the buyer and the supplier about where perhaps there are issues or potential areas of violation, and we're giving clear direction to the supplier about what they need to do to improve to address those areas. And then we're allowing the buyer to take a view of how important those aspects are and set clear deadlines for when the supplier needs to have addressed those corrective actions. And all of this is structured within the platform so that it is a structured way of being able to manage this whole end-to-end process. I have a couple of screenshots on the next few slides, which I'm going to just jump through quickly so that we can hopefully get to some questions at the end. But this just shows that not only is this process, I guess, structured, but there is a whole host of data that is available to the users of the platform to support in wider reporting. So we're very conscious that BAFA are expecting an annual report from organisations in relation to the activities and the risks that you're finding as organisations when you have implemented the Act. And while unfortunately the system, you can't press a button and it pushes out and creates the report that you need to submit, it definitely incorporates a lot of the data that you need to support the submission that you're going to have to create. So for example, demonstrating suppliers that you're engaging and tracking the response rates. If we move on to the next slide, it's showing you the supplier evidence and where we're finding discrepancies in your expectations and what the supplier's capability is. It's giving very clear guidance to suppliers on what recommendations and corrective actions they need to take, and giving you a dashboard of what those most common areas are. Because part of the risk management process that you have to implement is not only giving that feedback to suppliers, but feeding in the knowledge and the intelligence that you're collecting from your supply base as part of your ongoing risk analysis process, which Sarah mentioned needs to be undertaken on an annual basis. So the kind of data that we're collecting in the platform from your suppliers can help you with that annual risk assessment process that you need to undertake. And then finally, as I mentioned, once we have identified the corrective actions that suppliers need to take, you then have the ability to be able to set clear deadlines and communicate that through the platform, and use the platform to monitor suppliers' process and how they are taking action and if they have taken action by the due dates. So a lot of these things clearly you could manage on spreadsheets and you could manage in that way with suppliers. But if you're working at scale and need to engage lots of suppliers, this is obviously the way that we have approached it to support our clients. So just by way of a final summary, I think it's important that some of the takeaways for today are as follows. Clearly, it's important that the requirements of the Act really do need to be implemented into business as usual processes. So this isn't going to work if you're just bolting on some additional aspects and hoping that that will demonstrate to BAFA and others that, that you are doing something. To really make this work, you need to look at how these can become part of your business as usual. You're clearly going to need to consider updating process and practice, because you're not only going to need to assess suppliers initially, but you're going to need to consider how you're going to do that ongoing compliance monitoring. Where issues are found and where violations are found, you need a mechanism to be able to provide feedback to suppliers and manage and monitor timelines for resolution as required. You need to think about how you're going to address doing something similar with indirect or sub-tier suppliers if a potential violation is identified through the complaints mechanism. And then, as you would expect, I'm a little bit biased, but if you're going to do this in an efficient way, perhaps consider the use of technology to support your ongoing compliance management. So that's kind of it for the presentation. Thank you very much for listening. I hope that both sides of this session have been useful and perhaps given you some food for thought on your own implementations within your organization if it does apply to you. What I'd like to do now is just look at the questions that we've been receiving as we've been presenting and try and answer some of those in the last few minutes of the presentation. Anke and Sarah, I don't know, you've probably had a chance to look at them a little bit more than me. Are there any questions that you'd like to pick up to start with?
Yeah, maybe Fedor, you can.
Yes. Yeah,
yes, apologies.
Walk us through the questions. Not as many as last time in the German session, but I also want to mention if any questions come up later after you've maybe taken a look at the slides again, then always feel free to contact us directly.
Yes, of course.
Please.
All right. The first question I wanted to ask is, I was wondering if the new act applies to companies that only have online presence in Germany. Also, how should we interpret the term principal place of business? Maybe some of you have an idea.
As I already said, yeah, where we already addressed this is the administrative or factual headquarters doesn't mean that the company needs to be registered or have the company seat within Germany. So if the say it again, what was the precise? So I in any case, it's not required that a company is registered as a German company. It is also possible from a corporate law point of view that a company has its headquarters or official headquarters and is registered, for example, in France, but carries out its business all from Germany. And so the administrative seat or factual seat would be in Germany.
I think the question was about online presences.
Yeah, but
so yeah, so what you said, that would not be, I understand there would not be any people within Germany.
Yeah, I'm also not really sure what is meant by online. Sorry, I
Maybe
didn't see
this
the
is something we may pick up later if you would
of course.
like this question.
Yeah, we can look into that and then we come back to you after this. Then one question we had is, do the due diligence obligations also apply with respect to providers of basic services such as cleaning services or catering?
Yes. Well, there are some voices in the legal literature which think otherwise, but the Federal Ministry of Labor and Social Affairs is pretty clear in their view that such basic services would also be covered. Nevertheless, you can bear in mind that as you are able to prioritize the risks, this may be a sector which is not like as high risk as other supplies you receive for your products or services.
All right. Then a question that was asked during registration. How can we gather reliable but inexpensive information on the abstract country risks of our suppliers' countries?
I think there are a number of sources, open sources of data, especially in relation to human rights risks. So in the US, the Department for Labor have actually in the last month just published their latest kind of risky countries in relation to child labor as an example. There are also sources from like the World Bank. So there are other kind of open sources that give an overview of kind of wider country risks. And I'm happy to feed back to that individual and provide some of those sources if that's of interest, because there are quite a lot of free kind of open resources that are from respected organisations that give a view of potential country risk in different sectors, so relating to kind of forced labour and human rights, but also environmental risk and other aspects. So we can give you some feedback on that of potential sources.
Reports of NGOs, for example, like Amnesty International, and that's an example.
Yes.
That can also be used.
All right. We are now at the end of our time, unfortunately. Thank you so much to all the speakers today. Thank you to Anke, Sarah, Claire. Of course, there are a few more questions left. We will be answering them after the webinar has ended, and we will come back to you. If there's any more questions, please do not hesitate to contact us. You will get the presentation, the video record, and the contact info later on in a follow-up mail. So yeah, thank you so much. Hope you have a great day.
Thank you.
Thank you also from our side for your attention. Goodbye.
Bye.
Great. Thank you. Have a good evening. Bye-bye.